Let's bring in trial attorney Misty Marris. And, as we wait for them to update us, Misty, on what's exactly happening in Madison, I do want to emphasize that we don't know the circumstances here other than they think it was a juvenile shooter who's now dead. Two others have been killed in this. There's, I think, at least 6 injured, some maybe severely injured. We'll wait for an update on that. But on this issue of parental responsibility, in this case, according to the report from the Associated Press, 9mm pistol, and we'll want to ask questions, right, about how this juvenile acquired that gun.
Right, absolutely, and terrible tragedy. I just have to start by saying that. What a horrific set of circumstances. But to your point, Connell, that is where investigators are going to start. The question is going to be, where did this gun come from, and how did a juvenile access it? And we see on scene that there's the ATF. The ATF is there, and that means they're tracing this gun, which has now been identified as a pistol, or reportedly as a pistol, that they're tracing that to identify where it came from, who's the owner, and that information is going to lead to answers relating to how did this individual get into possession of this gun.
And what type of questions then do you want to ask? It's one thing for a parent or a relative or somebody to own, lawfully could own a 9mm pistol, I'm sure, right? And what responsibility from those other cases, whether the Crumbley case or the Georgia case, what have we learned from those cases about where parental responsibility kind of begins and ends in situations like this?
So there's several different legal theories that could be at issue here. And again, we don't know exactly the circumstances in this particular case, but generally there's safe storage laws. In Wisconsin, that is a misdemeanor if a child under 14 is able to get their hands on a gun that's not stored adequately. So that's one aspect. Then you move up to the next level because that's a misdemeanor. Wisconsin actually has a statute called felony neglect. And Connell, this type of statute is used in general with accidental shootings where a child is able to access a gun and actually injures themselves. And those parents can be prosecuted under that legal theory. Then, as we've seen, you've pointed out in the Gray case and in the Crumbley case, the theory has been extrapolated to even include reckless homicide. So unintentional murder where a parent can be held responsible for the acts of their child. Now, that requires notice, a reckless disregard to a known risk, and also the other critical component, the accessibility of that firearm. And did the parent know that there was a proclivity for violence? So those are all the different aspects that law enforcement is going to be looking into as they continue to investigate this case.
How would you describe those laws in Wisconsin compared to other states? I mean, are they more aggressive? Are they or do a lot of states have similar laws now? Or?
Well, so at first, the laws, there are some safe storage laws, especially after the Crumbley case. That became something that legislatures worked overtime to get those laws on the books. Because if you recall, in Crumbley, there was no such statute relating to the storage of a gun specifically. So many states have made those changes. Now, the safe storage laws in Wisconsin have been on the books for a long time, since the 90s. However, they were only allowing charges as a misdemeanor. You see that the severity level is ranked up now because since 2017, there's a new statute that could apply relating to what would be a child neglect statute. So it certainly has some similarities to other statutes we've seen that are really cracking down. No access to the gun means that a child cannot use that gun and cause an injury to themselves or others. So it's all in an effort to remove that accessibility of a gun in the home.
Because it all kind of feeds into the same question that was asked of Tracy Walder earlier. She's a national security expert. You're a legal expert, so the answer might be different. And when I was talking to her, I was saying, hey, what are we not doing? This happens. Obviously, everyone says it every time. It happens way too often. You see scenes like this with parents running into schools to check on their children. We've seen it for years and years and years, going back to Columbine in this country. So from a legal perspective, so these laws come in, we're reactive, we see something happen, try to put laws in place. I mean, do you have any thoughts on anything more we can do?
Yeah, well, Tracy made some great points about security and all of the aspects to actually physically keep the schools safe and try and keep guns out. But a lot of these issues, Connell, as we've seen in the cases that we've covered together, it starts at home and it starts with observing behavior that could be problematic. Nobody wants to believe that their child is capable of doing something like this. But when you have information or that a child is troubled, and then that's one thing. But then you have a gun in the home that's accessible.
Well, that was what was so disturbing about that Georgia case.
Right, exactly. And so now we're in a whole new world where typically there would be a causation element that would be cut off, where a parent would really not be held liable from a criminal perspective for the acts of their child. That was
Right.
pretty universal, but that's really shifted and changed. And to that point, that is a deterrent, and that presumably would be a deterrent effect as more of these cases work their way through the courtroom.
You see the microphone set up. Thank you, Misty. I want to squeeze in a commercial break so that when we come back, we'll have an update from authorities, Madison, Wisconsin, on the school shooting that we've been covering throughout the afternoon. We'll be right back.